In the early 2000s, the Ohio Court of Appeals ruled litigation finance agreements must be classified as loans and were subject to usury laws. But the Ohio Legislature responded to this ruling by enacting a regulatory statute that permitted litigation finance transactions. Today, Ohio provides a model of well-conceived regulation for litigation financing. In 2001, the legality of litigation finance transactions was directly addressed in Rankman v. Interim Settlement Funding Corp. That case arose from an ordinary litigation funding transaction in which a plaintiff received an advance against any settlement or judgment. When she received a recovery, she declined to repay the funder and challenged the legality of the funding agreement. The appeals court held the financing agreement could not be enforced because it was a loan. In the court's view, given all of the circumstances of the underlying lawsuit, the transaction could not be classified as non-recourse because there was no real risk that the funder would not be repaid. Consequently, the court held the contract was invalid for two principal reasons. It had not been executed in accordance with the formalities required of loan transactions, and it was usurious. In 2008, Ohio enacted a statute that permits litigation funding transactions when they conform to certain requirements. For the most part, these requirements pertain to disclosures in the form of the document that memorializes the transaction. In addition, the statute requires the litigant's attorney will make sure any settlement payment or recovery is paid into his or her trust account for payment to the funder and client. The statute also mandates the agreement cannot impose upon the attorney any duties contrary to the Ohio rules of professional conduct. The statute does not, however, impose any regulations on the amount of fees, the accrual of interest, or the time period upon which fees can be charged. The advantages of this statute are clear. It permits litigants and funders to make any agreement they wish regarding fees and the structure of the investment. But it also assures that adequate disclosures are made to the litigant about the nature of the transaction, and that there will be no compromise of the attorney's ability to represent the litigant's interest alone. This is the kind of statute that protects litigants while maximizing the incentives for funders to make investments. If you need help with litigation funding, call or email me today.